Good morning, I'm Gary DeWaal, and this is Bridging the Week for February 15th to 19th, and today is February 22nd, 2016. A review by the Inspector General of the Securities and Exchange Commission concluded there was no home court advantage for cases tried before its own administrative tribunals, while the Financial Industry Regulatory Authority announced a sweep to help evaluate broker-dealers' compliance cultures. Meanwhile, the Singapore Exchange proposed to amend its rules to ratchet down a somewhat prescriptive approach to regulating automated trading systems accessing its electronic platform to a far more principles-based manner. Unfortunately, I have a very tough day in store for me, so I can get back to my day job. Let's get started. The Financial Industry Regulatory Authority advised some broker-dealers through a targeted exam letter that it will soon meet with them to learn how they establish, communicate, and implement their cultural values. In particular, FINRA seeks to determine how broker-dealers reinforce their cultural values through compensation and how they monitor, quote, for implementation and consistent application of those values, end of quote, throughout the organization. FINRA implied it considers a good firm culture one, quote, that consistently places ethical considerations and client interest at the center of business decisions, end of quote. FINRA has requested from each broker-dealer with whom it will meet, among other documents, a summary of key policies by which the broker-dealer establishes cultural values, and a description of the processes by which the firm communicates and implements cultural values, assesses and measures the impacts of such values, identifies breaches, employs compensation to reinforce cultural values, and identifies and remedies subcultures within the firm that do not follow the firm's cultural standards. All documents must be provided to FINRA by March 21, 2016, or a selected firm must disclose that such documents do not exist. Identified broker-dealers were alerted by FINRA that, quote, this inquiry is not an indication that it has concerns about your firm's culture or has determined that your firm violated any rules or regulations, end of quote. Instead, FINRA suggested it solely is seeking information to develop potential industry guidance. Charles Moore, the former chief executive officer of broker-dealer Crucible Capital, was sentenced to 6 months in prison for obstructing a Securities and Exchange Commission regulatory investigation. The U.S. Attorney's Office in New York City previously filed criminal charges against Mr. Moore for having a Crucible employee falsify certain invoices received from third-party vendors by removing mention of past due balances in order to support certain Crucible SEC-required capital computations. The U.S. Attorney's Office claimed these altered invoices were subsequently given to the SEC during an examination of Crucible. The Office of Inspector General of the Securities and Exchange Commission issued a report of investigation that concluded that SEC-related hearings before administrative law judges were not conducted under improper influence or reflected a home court advantage. The Inspector General's inquiry was prompted by a complaint of bias by an administrative law judge leveled by Erica Williams, a former deputy chief of staff in the SEC's Office of the Chair. In June 2015, Ms. Williams complained about, quote, alleged potential issues of fairness and bias in the SEC's administrative proceedings, end of quote, including similar allegations previously made by Timbervest LLC in connection with an SEC administrative proceeding against it brought by the agency's Division of Enforcement. As part of its investigation, the Inspector General interviewed numerous SEC current and former ALJs and reviewed relevant documents. In the end, the Inspector General's office noted, quote, it did not develop any evidence to support the allegations of improper influence, end of quote. However, the Inspector General's office did identify some issues related to the timeliness of some ALJ decisions and or the procedural quality of ALJ's work. Charles Graham, a former managing director and equity research analyst at Deutsche Bank Securities, agreed to settle charges brought by the Securities and Exchange Commission that, in 2012, he rated innocent certification and promoted a company stock as a buy. At the same time, his personal view was that the stock rating should be downgraded. According to the SEC, this certification caused Mr. Graham to violate an SEC regulation that requires research analysts to certify research reports attesting that all the views expressed in a report accurately reflect the analyst's personal views. According to the SEC, on March 29, 2012, Mr. Grum issued a research report on Big Lots, Inc., where he recommended the company as a buy. On the prior day, Mr. Grum allegedly recommended selling the stock to 4 hedge funds because of his personal concerns about the company's financial performance. According to the SEC, Mr. Grum rated the company as a buy to maintain a good relationship with the company's management. Mr. Grum agreed to pay a fine of $100,000 to resolve the SEC's charges. And finally, the Singapore Exchange proposed a host of new rules to reflect the replacement of its current derivatives trading system and SGX Clear, its current clearing system, with a new trading and clearing system, SGX Titan. This new system is expected to be implemented by the end of 2016. Among the many proposed rule changes are rule amendments addressing pre-execution checks, error prevention alerts, and fictitious transactions aimed to accomplish many of the same objectives of recently proposed rules by the Commodity Futures Trading Commission in the United States, known as Regulation AT. Among other things, SGX's amended provisions transform formally detailed prescriptive requirements into broad principles-based obligations. For example, instead of mandating that a host of specifically enumerated pre-execution checks be conducted on all orders, SGX's new proposed rules broadly require that, quote, members ensure that automated pre-execution risk management control checks are conducted on all orders. The checks must be appropriately set to effectively limit the firm's risk exposure arising from all orders to prevent the taking on of excessive risk, end of quote. Comments on the new rules will be accepted through March 10, 2016. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, well, always, I'm Gary DeWaal. Until next week, have a great week, and ciao!